Hello, everyone. Welcome to the Safe House, brought to you by the Safe House Initiative. I'm Jeff Edwards, co-chair of the Safe House Initiative, and your host for today's podcast. Thanks for joining Tawana and myself once again as we delve into the world of cyber insurance. Now, last week, Tawana, refresh our memories who we had talked to.
Well, Jeff, last week we talked to Tony Sukan, who explained to us the process of adjusting cyber claims.
Yeah, and she made it sound so understandable and so simple, and the story should end there, right? Or knowing the way I know you, you have something up your sleeve that's not as clean and neat as that.
Yeah, you do know me a little too well, I guess.
Yes, I
No,
do.
unfortunately, the cyberclaim is not the end of the story. As our next guest here, my partner, Chris Wood, is going to explain to us. He's going to talk to us today about data breach litigation. Hi, Chris.
Hello, how are you today?
Doing well, thanks. Thanks for joining us.
My pleasure.
Chris, do you mind just kind of introduce yourself to the audience and explain a little bit of your background?
A chance to talk about myself? Of course, I don't mind. I am, as you said, we're partners at a firm called Lewis Brisbois. We're national in scope. We have offices all over the country, which is very helpful for this practice because the data breach litigation that we talk about and the data breach litigation that we defend happens all over the country in federal and state courts. So we have presence there that really helps make my job much easier. I am a complex litigator. That means I've been practicing for longer than I'd like to admit, so I'll just limit it to how long I've been doing class cases, which is 20 plus years, and with focus on antitrust, but much more present in my work these days is the cyber cases. Since about 2020, about 5 years, I've been focusing very much in the cyber area because, as we all know, the amount of activity in the breach world, we see it all the time in the news. It's very, very present for all of us. And that translates into the world that we know in the United States is litigation. And so you have these data breaches and they flow into litigation. And I do a lot of that these days. I've done dozens of those cases and we have a healthy portfolio today.
I can attest to that as you and I have worked together on several of those cases.
We have, my friend, we have indeed.
Yes. So, Chris, let's just kind of start at the beginning from the litigation perspective. So, how does a data breach class action get rolling?
Sure. I guess the obvious statement would be with a data breach, right? You start with some type of incident. And as you well know, and I think your audience has perhaps heard in some of the other podcasts relating to this series, once you have an incident, oftentimes there are reporting obligations that emerge on a state and federal level. When an entity reports, there are some state entities that will make that disclosure public. They will share it through some type of portal, some type of website. And the plaintiffs' lawyers in this area, in the data breach area, have become very sophisticated and wise in terms of monitoring those locations where information about those breaches will emerge on a state attorney general website, for instance. They'll monitor those websites, they'll see the activity, and they will, if it's attractive to them, the plaintiff's bar will basically engage in marketing and seeking out clients through much internet presence. So the cases often originate with a regulatory disclosure of some sort, the plaintiff's bar watching that, boom, there you go, it ends up in a lawsuit.
Yeah, I'm very familiar with those quote unquote wall of shame sites that the regulatory reports are posted on, unfortunately. Um,
And they
so,
are lengthy. They are lengthy, my friend. And that's one of
yes,
the things about the
yes.
data breach world we live in today.
Yeah, we've talked about it briefly before, that the applicable law is based on the residence of the individual, not the business. So as long as one individual is a resident of Maine, then, you've got to file that report in Maine. And every single one of them goes up on that website, and it goes back for years. As you say, it is staggering for sure.
Right. And the I shouldn't call it a downside, but as an entity disclosing, as you well know, Maine will not just say there's one Maine individual, but they will list the total population for which reporting was done. So
Yep.
there may be 3 people in Maine, but 872,000 people. And
Yep.
as you can imagine, the more people that are potentially impacted by the incident, the more the plaintiffs' firms can get interested, because larger numbers of people generally register as dollar signs in terms of potential recovery for which that group of individuals, what we might call the putative class, can potentially obtain.
Chris, what kind of claims are these plaintiffs usually bringing in the class action lawsuits? What are they claiming?
Sure. The claims can be a little bit all over the place. Anything from a contract-based claim of a breach of an express contract, meaning you and I have a definitive agreement, maybe it's set in writing, an implied contract, which is based upon the circumstances. Other types of claims, such as an unjust enrichment theory, where the idea is that you're holding data for someone and you're profiting from that, but because of the incident, that person has lost something. And claims such as negligence or negligence per se, but they all filter back to this notion of negligence. And the contract claims do as well. If you enter a contract, that creates some type of duty. But at the heart of all these is this notion that you have a duty to me, the consumer or client or employee, to maintain that information in some degree of reasonable privacy. So again, Tawana, at the heart of all this is the notion of a negligent type state. You had a duty and you didn't fulfill it.
Chris, don't these plaintiffs need to show that they actually suffered some kind of harm in order to be able to bring a claim?
Well, that all depends on your definition of harm. One of the things, and it's very important topic that you raise, because many of the clients that you and I deal with, they feel like they are the victims, and rightfully so. Their systems have been attacked maliciously by some hacker or third party, and they feel that they are the ones who are subject to the real harm. You very, very seldomly hear anything about what I would call an actual loss. What you do see are positions that take kind of these lines. Number one is, I have a nominal damage. I suffered some kind of nominal loss in terms of what happened to me. Another view is, I've lost time. I had to spend time making sure my credit accounts were good, that my financial institutions were continuing to maintain my information and my finances in a proper state, that someone wasn't playing around with that and causing trouble. And so there's time and value to that. What we're dealing with here is the presence of damages is hard to trace, but when you talk about loss, when you talk about overall effect, the plaintiff's lawyers can come up with ways to say there are damages. And so the thought that, oh, there are no damages, so I don't have to pay anything, that is a very dangerous approach to assessing your risk when you're thinking about whether and the extent to which you need cyber protection for your data environment.
So, Chris, how frequently are you seeing class action data breach litigation involving small to mid-sized businesses? Isn't this more like the larger, like Equifax, Change Healthcare? Are you seeing data breach litigation for smaller businesses as well?
I sure am. And that is another very valuable observation, or question, I should say. In the beginning, as we say, when these cases first started rolling out years ago, and several of us, I actually was a member of the Equifax class. I have something like 7 years of credit monitoring or something because of that. But back in the day, the plaintiff's bar would target the really large breaches, because in the traditional view of dollars and cents in the class sense, The more people in the class, as I said before, the bigger opportunity apparently for a big payday. So the targets used to be very, very large entities and organizations who had massive number of clients, employees, personnel, consumers, whoever it was that was the subject of the incident, right? In this day and age, it's very different. The conception of what is a worthwhile case to pursue, if you will, has changed. We've gone from cases where the focus is millions of people to literally maybe 1,000, 1,500, 600, 700 people. And the reason is, I believe that the plaintiff's bar has recognized that if I go after always the big fish, there are other big game hunters with me. From the perspective of the plaintiffs and the lawyers that represent them, the notion that, well, if I can go after this guy or that guy, and there is money to be had. And this brings in the notion of insurance policies, right? And so entities, big and small, have cyber policies. And the plaintiffs' bar know that that money is likely there and potentially useful for resolving the matter. So if it's even just 1,000 people who are affected, that case very well may be appetizing to a plaintiff's firm, particularly because in those situations, these smaller cases, which inevitably will often involve, just by definition, small to mid-sized businesses, they are absolutely in the target today.
And Chris, you bring up a really good point too about the size of the classes here. I remember the very first incident that I handled that ended up in litigation. It was 300 and some odd thousand people, and I was flabbergasted. That was the most that I had ever seen at that point. But we're definitely seeing much smaller class sizes now. What do you think is kind of attributing to that? I know you just talked about obviously the plaintiffs' law firms, but is there anything else that you think might be playing into that?
Well, there's a little bit of a feeding frenzy that's developed. The number of data breach class actions that were filed on an annual basis when I started doing this work was a couple hundred or so.
Is that nationwide?
Nationwide, a couple hundred. Last year, there were close to 1,500 cases that were filed in federal and state courts. So you're looking at, what is that? It's a sixfold increase, right?
Wow.
From one time zone, one time parameter to another, right? And so what I think you're seeing is that the cases have legs of their own. And there were, if you will, a traditional group of lawyers on the plaintiff side who were focused on this data breach area, and they would show up at almost every party. Now there are lots of other plaintiffs' firms, small, medium, whatever they might be. Oftentimes they could be just a couple lawyers in a small boutique firm that now roll out these cases. And so there is an appetite that exists because the cases continue to oftentimes be settled. Know this, as of today, as best I know, there has never been one of these type of data breach cases that has gone to trial. The cases are either resolved beforehand through a settlement or some form of dismissal based on the defenses that are raised by the defendant in the case.
Wow. Going into a little bit deeper, the class size here, I've heard, stories of class sizes as small as 600 people now. What are you seeing actually kind of, in the field? What kinds of class sizes are you actually encountering?
Let me give you an example. So in my docket right now, my portfolio cases, my largest case, or one of the larger ones, is well over 2 million people. My smallest case is, I think, 1,012 or 93 or something like that. And that's a good model to think about in the substance of this discussion we're having. You could be a small business, but try to contemplate whose data you have and how much do you have of that data. So you may, for some reason, be a retailer that has done transactions with 750,000 people. And for each of them, for whatever reason, maybe you have some what we call PII, personally identifiable information, right? That's exactly the type of information that a hacker, that someone who wants to engage in ransomware or just cause trouble may be interested in. So even if you're a little guy or little girl in the marketplace, you may have a lot of data. What would be the consequences if somebody got into my system? There are cost benefits analysis that have to be made all the time, but that's a consideration. But back to your question, yeah, you are not incorrect. The classes can be very small, and that's because there's chum in the water and there's opportunity and there's dollars to be made, and on behalf of the clients as well, money to be allocated and provided to settlement classes or litigation classes.
So, Chris, I know you said earlier that none of these cases has gone to trial yet, and they all settle. What kinds? How do we determine what a fair settlement value is? What kinds of factors are we taking into consideration here?
Sure, sure. I will say that when I think about settlement values, one thing that I see that has remained relatively consistent is how one thinks about settlement in a data breach case. There are certain factors that come into play when you think about that. Number one, what is the size of the class? How many potentially affected individuals? There are these factors. The first one that I just mentioned was the size of the class. The second factor that I would include would be what is the type of data? There's something very different about having Tawana's social security number versus having Tawana's mailing address, your home address. What a bad actor can do with that are very different things.
Mhm.
And courts recognize the potential implications of what has been accessed. I would throw in another element, which would be what's happened to the data. Has that data actually been taken? Has it been exfiltrated, as they say? Has it been put into the hands of bad actors? And are those bad actors doing anything with that? Usually, as I said, in the cases that I do, it is very, very, very rare that that has happened. But the primary movers and shakers are going to be how many people and what is the data that was involved in the incident.
So what is the general range? I know that might be a difficult question to say, but am I going to walk out of a class action with $7.52 while the plaintiff's attorneys are walking out with 5 million? Like, how is that working?
Well, I'll give you a lawyerly answer to that. It depends. It really depends. As you think about the class sizes, obviously, if you have 1 million people versus 1,000 people, there's not a general rule that everybody gets $100, right?
Mhm.
Because it becomes cost prohibitive at some level. So there is some rationalized thinking about the larger the class, if we're going to put a per dollar amount on each individual, that's going to start to drop precipitously as you increase the number of people. So you might have a class of 1,000 people, and you might say, oh, well, the value is $42 a person. I'm just making this up. This is not any attachment to reality. But
Right.
and for my hypothetical, it's $42 a person. But if it's 1 million people, it literally may be 42 cents a person or $4.02 or whatever it is, right? And so depending on different class sizes, you may have different ranges that we within the field will think about. Okay, if it's 100,000 people, that range is going to be $12 to $18 per person. And so you have kind of a preset notion of what you're dealing with when you want to actually try to resolve the case. And again, that range I provided you was just a number that I made up.
Sure.
But you generally, again, are driven by that class size and then the sensitivity of the information. I will push back as a defense lawyer much harder if I say, this is what I consider to be record information, or as the casual consumer might think, phone book information.
Mhm.
Folks, I can go into the phone book and find the exact same information that you're crying is the end of civilization, right? And so I'm not really buying the effects that it has on consumers. I understand why it may be very upsetting, but when it comes to the actual dollars and cents and valuation of loss, those are aspects that I, as a defense counsel in these cases, surely have to take into consideration when trying to figure out an appropriate resolution so that the plaintiffs and the members of that class can be compensated for loss in some fashion, and that my client is able to sustain that and continue with its business operations.
Yeah, completely understand that. That makes perfect sense. So, Chris, earlier you said that you see these cases filed in both state and federal court. Um, is there a preference for state or federal, or a particular state or a particular district for plaintiffs' attorneys?
It depends on the lawyers. Lawyers like to often operate out of their backyard.
Mhm.
There are lawyers who like to be in California. The California aspect of this can be very enticing because there they have access to laws that provide for statutory damages. And one of those statutes is the California Consumer Privacy Act. And gosh, there are statutory damages that accompany that can range from $100 to $750, depending on the severity of the activity and other assessments of the actual damage. And let's say there are 20,000 people, using that number again. And let's say we were on the low end of the statutory damages. They can come to me off the bat and say, oh, yeah, I got the common law stuff like I do every other day. But I also have these statutory claims. And even if I'm on the low end, 20,000 people times 100, my little head's trying to calculate that. That's about $2 million, right?
Yeah.
So there are advantages if you can get statutory claims to proceed at least with those statutes. And a lot of the bar in this area for the plaintiff side are in California. And so they may prefer that venue. But in terms of states versus federal courts, that may often be the preference of the individual litigator, the individual plaintiff's counsel. A state court can have certain advantages if you play your cards right. The state court judges often don't have a lot of class action experience, unlike their peers on the federal side, the federal district court judges, right? So the plaintiffs oftentimes can perhaps flow through those cases a little more fluidly because the state court judges are perhaps not as seasoned in dealing with those type of claims. And so the flow at times in state court is to allow to say, oh, well, let's move this case along. Then I want you to go settle the case. So again, Tawana, I don't mean to do this to you, but it really depends on the circumstances driven by the plaintiff's lawyer. The plaintiff is the master of their complaint, and where they want to file that can run on various aspects that you talked about. Where does the plaintiff reside? Where's the defendant? Where do the events that happen precipitate all this? So those can all drive the factors in terms of where a plaintiff's lawyer is going to file those cases.
You were talking about the CCPA earlier. Does that put California businesses at a greater risk of facing these types of data breach class actions?
That's almost a red herring of sorts, because a lot of entities have a comprehensive presence throughout the country. They have a website presence, for instance. So yes, if you're a California business, that certainly is something that will probably pop up because of your physical location. But if you're an entity that does business in California, for instance, you're a retailer and you have a website and they're California consumers that are interacting with your business, then those California consumers through that statute can exercise those rights to try to protect their interest under the applicable law.
Right. Exactly like I was mentioning before when we were talking about the Maine Attorney General website.
You got it. Right.
All right. So, Chris, can you kind of give us an idea on some practical steps that small to mid-sized business owners can take to mitigate the risk of getting a data breach class action filed against them, in the event of an incident?
Sure. Well, I was going to begin to say, just like my other answer, don't have a data breach. That's your easiest recipe for success. But in responding to that question, I harken back on my experience dealing with my clients, but also a lot of the experiences that you and I have had together. It's about preparation. It's about putting in place policies and procedures that will help you prevent or mitigate the effect of an attack. One thing to think about, obviously, are implementing the proper data security protocols that will allow you to best protect in a reasonable fashion the data that you have. For small and medium-sized businesses, there's a risk cost analysis, right, that you have to take into account because maybe you just don't have much data. What are the implications of not having a robust policy versus, hey, we just have Microsoft Defender, whatever it is, right? So there are calculations that have to be made. But if I was in a world and I'm not thinking too hard about the financial aspects of it, the first thing that comes to mind is put in place some type of policies, procedures, and protocols that are going to minimize the risk of that incident, or if that incident happens, the effects of that incident on the data that's in your possession. And so flowing from those policies and procedures, you probably want to do some audits, or what we call pen tests, meaning penetration tests, where you're basically probing the system to see, are there any vulnerabilities? Are there any ways that we can improve that system? You're constantly in motion of anticipating, preparing, detecting, countering, blocking activity. And one way to think about that too, are there various standard organizations that provide information, frameworks for how a system should be set up. There are NIST and IST standards, there are ISO standards. If you follow those, or you're in compliance with them, again, this is something that has to be sensitized to the monetary extent of the entity's coffers, right? How much money do they have to invest in these type of resources? But the goal is to find the best way to minimize the risk. And that's through working with data privacy lawyers, bringing on somebody, having sophisticated IT personnel. Maybe you're outsourcing that, but putting together some program that allows you to help fend off those attacks, and then have in place policies and procedures to respond to those attacks when they happen, and work yourself through the process at that juncture.
Absolutely. And Chris, you bring up a good point here too. With different sized businesses, is there a different, I don't want to say standard or duty of care based on the size of the business? If it's a small mom and pop shop, they still have a duty to protect the data, but is there sort of a sliding scale as to what's reasonable there in terms of efforts to protect the data? I mean, I wouldn't expect, the one man mom and pop shop to have the same level of security measures in place that, Apple or Nvidia or, some of the larger tech companies would have in place.
It's an excellent question, and you're hitting the right chord on that. For those type of scenarios, you do, when you're considering the question of negligence tends to look at what would a reasonable person do in that situation with the duty that they have or may not have, right? And so if you're a mom and pop and you're on Main Street, and a lot of your transactions are cash transactions, and you obtain very little information, personal information or health information of any sort, right? The extent to which you need to have some robust policies and procedures, and these things about getting data privacy lawyers involved and all that stuff, those are questions that certainly would be presented in the framework of what type of business you're in and what type of data you have. I do want to caution, though, as I mentioned before, that you could be a fairly small organization and have lots and lots of data, and you may have lots of data that is very significant to the individual, including health information. And so one of those things that as an entity one has to examine is, well, what do I have exactly? I could be a tiny place, but for the basis of my business, I may accumulate a lot of data that's very sensitive. That would change, at least for me, the perspective of what you should be doing to protect that information.
Yeah, completely agree. That makes perfect sense. Are there any states that you know of that allow a business to claim a certain affirmative defense in the context of data breach litigation?
Yeah, so that's an interesting topic too. Some states have taken the position that an entity should not be thrown into the coals, right? Thrown upon the coals if they have taken what one might say reasonable precautions to try to protect the data that is in their possession. And the first state to roll something out in that measure was Ohio. And Ohio statute basically said, look, if you engage in these reasonable practices, you could get a pass on people trying to bring actions against you. It almost creates an affirmative defense of sorts that you can apply as a defendant in a case. And the question then but what is reasonable? How do you measure that? And so Ohio, for instance, says, well, there are these standards, as I mentioned, the NIST standards and the ISO 27,000 series that you could think of, that if you can be compliant with those and generate information and demonstrate that you're in compliance with those standards, whether you're certified or not under the standards, that can be a way out. So Ohio implemented this legislation probably 7-ish years ago. Utah now has a statute. I believe Connecticut and Iowa do. Oklahoma, Tennessee, and others have been playing with the idea. I know Florida maybe actually passed a statute, but I don't know if the governor signed that into law as of yet. So it is a very active area. But from the perspective of the small and medium-sized businesses, that would be something, maybe this is the back door that you're trying to go to, Tawana, is, hey, you might want to look out where you are as an entity and as a resident, and where you engage your consumers. And maybe you have agreements with them that, hey, if we have a dispute, that's going to be governed by X law.
Yep.
That's something to consider. Yeah, absolutely. Something to consider, because if I have that, then why not work towards that standard that gives me the get out of jail free card?
Yeah, that makes perfect sense. So, Chris, then the next question I have is, what can a small to mid-sized business owner do to proactively prepare, both from a legal perspective and operationally, for potential litigation? And I know we've talked a little bit about some of this stuff, but is there like a top three list of things that you recommend, or anything specific that you can point to, for our listeners here?
Sure. The most practical consideration I could think of is get a cyber insurance policy, something that's going to protect you through an insurance mechanism if something was to go awry and you ended up in the crosshairs of litigation. And there are lots and lots of policies. So you really want to work with a broker or agent who is experienced and versed in the subject matter, who can get you the right type of policy for, as you mentioned before, Tawana, the needs of Microsoft versus the mom and pop retailer on Main Street can be very different. As we talked about before, in preparing for that litigation, you want to make sure that the steps you're taking, if you're put in that situation, avoid digging a deeper hole. So there are considerations that one would work with your response counsel, these people who come in and are lawyers who try to help you with the regulatory requirements, making sure you're not digging a hole by making certain concessions, for instance, that may or may not be factually correct in terms of how the incident happened, what happened to the data, considerations about who you notify. Sometimes there's a knee-jerk reaction to say, well, we just should notify everybody who's a customer. But that, as we talked about, goes to perhaps class size. So you may want to spend the time trying to figure out exactly who may have been impacted. And another broad consideration, I think, would be look at your relationships. So let's say you get data from customers, and perhaps as a small to medium-sized business, you don't have the bandwidth to maintain that or store it. And so you outsource that to a third party. Or perhaps the way your business operates, you need to provide that information to another entity to perform your services or to provide your goods, right? And if you're in that chain, remember that if the data is coming into you, you have an obligation at some level to make sure reasonable practices are not in place only where you are, but if you're giving that information to other people, that they have adequate plans, policies, procedures in place to protect that information. You should review your basic contractual structures. If you have a relationship with one of these people in the supply chain to manage data, are there indemnification provisions that help protect you? Are you treated as an additional insured on their policy in case something happens to them? This is all the notion that if something happens downstream at that other entity, you, as the entity who provided the information, may be roped into the litigation on this theory of what one might call negligent oversight. And I would say the same if you're an entity that has consumer agreements, that they sign up for things, and as part of the terms and conditions, for instance, you may have a provision within that provides for arbitration. I'm not saying arbitration is good or bad. That's a totally different subject, but there are ways to address the potential risk with both your supply chain relationships as well as the consumers, clients, and employees for which you may have agreements. So think about your contracts, your agreements with those in this data cycle. Think about what you would do in response. Do you have a plan? Are you ready to respond with the thought of litigation in mind? And do you have a policy for yourself to protect the business, to use insurance for the purposes for which we are provided it?
Jeff, did you have anything you wanted to ask Chris today?
Well, Tawana, I always like to ask, the one thing that people can do today. That, Chris, you've given us so much tremendous insight on this very interesting and complex subject, and it sounds like, especially for small mid-sized businesses, the risk is growing exponentially, and defining what is good, reasonable care of data is something that is kind of the crux of everything. Is that a good assessment?
If I was a small to medium-sized business and I was starting from scratch,
Yeah.
as we talked about, Jeff, I definitely would say, well, what do I have?
Yeah.
It's taking inventory and saying, okay, let's assume there is a data breach. What exactly would be breached, and what are the implications for my organization, and importantly, for the customers and people for whom I may have data? So that's kind of your first step. And you want to assess, not in a vacuum, but in a holistic sense, what am I dealing with? And how am I going to deal with that information? And based on that, then I can make reasonable assessments about how I need to proceed in terms of data protection.
Yeah. So assess your exposure and take a look at it from the data standpoint.
Exactly. I can't measure risk until I do an assessment of what that risk may be.
Interesting. Okay. Well, I'll tell you what, Tawana, as always, fantastic conversation. And Chris, what a fabulous guest you've been. And thank you ever so much for all the insights you've given us today. And you're most welcome back anytime.
Well, be careful what you say, but thank you for having me. Thank you very much. I appreciate you all very much.
Thanks, Chris.
And so, Tawana.
Yes.
Wow, you've really opened my eyes to a whole bunch of new things I had never even considered. And thanks, Chris, again. But so now, where are you going to take me next week? Because my mind is just filled with all kinds of things today. So what are you going to fill my mind with the next week?
Well, Jeff, next week we're going to continue talking about litigation, and we're going to have Jane Waring from Zell Law talking about business interruption litigation following a data security incident.
Oh, fantastic. Well,
should be a very interesting conversation as well.
I know the audience is going to love today's episode, and they're looking forward to next week's. So anyway, again, thank you ever so much, Chris, and you too, Tawana, for being such a great co-host.
Thanks, Jeff.
That's our podcast for today. I'm Jeff Edwards for the Safe House Initiative. Thanks for joining us, and remember, be safe, be resilient, and be kind to each other. For more information about the Safe House Initiative, please use your mobile device to scan the QR code on the screen or send us an email at info@safehouseinitiative.org or visit us on our website, safehouseinitiative.org. We look forward to hearing from you.